So, good day ma'am. I am Sublimente Mark Gibindi, fourth year college student of Western Philippines University. So, from Bachelor of Science in Criminology. Today, I'll discuss about the role of procedure for environmental cases. Under the role of procedure for the environmental cases. So, a Republic Act 8048, a Coconut Preservation Act, then the Republic Act 8435, Agriculture and Fisheries Modernization Act of 1997, and then the Republic Act number 9522, the Philippine Archipelagic Baseline Law, then the Republic Act 9593, the Renewable Energy Act of 2008, then the Republic Act 9637, the Philippine Burial Act, and other existing law that related to the conservation, developments, preservation, protection, and utilization of the environment and natural resources. So, number 1 is the civil procedure. Rule 2, pleading and parties, section 1. Then, pleading and motion allow. The pleading and motion that may be filed are complaint answer, which may include compulsory. So, counterclaim and cross-claim. A motion for a role of procedure for environmental cases. So, intervention, motion for discovery, and motion for reconsideration of the judgment, and motion for the postponement, motion for new trial, and petition for relief from judgment shall be allowed in a highly meritorious cases or to prevent manifest miscarriage of justice. Then for the rule 3, the pre-trial section 1, notice of pre-trial. So within 2 days from the filing of the answer to the counterclaim or cross-claim, if any, the role for procedure for environmental cases 15 branch. So clerk of the court shall issue a notice of the pre-trial to be held not later than 1 month from the filing of the last pleading. The court shall schedule the pre-trial and set as many pre-trial conference as may necessary within a period of 2 months. So counted from the date of the first pre-trial conference. And then for the section 2, the pre-trial, so brief at least 3 days before the pre-trial, the party shall submit pre-trial brief containing the following, such as statement so of their willing, summary of admitted fact, and proposed stipulation of fact documents, so or exhibit to be presented, legal and factual issue to be read or resolved. So the document of exhibit to be presented, including the deposition and answer to interrogatories and answer to awaiting requests for the admission by adverse party. So starting the purpose thereof, a manifestation of their having a bail, so of recovery procedure or their intention to avail themselves of referral to a commissioner or panel of expert. The number and the name of the witness and the substance of their affidavit, clarificatory question from the parties, and list of cases so arising out of the same fact, so pleading before other court or administrative agency. So then for the judgment and execution, so section 1, relief in a citizen's suit. If a warrant, the court may grant to the plaintiff proper. So relief which shall include the protection, so preservation or rehabilitation of the environment and the payment of attorney fees. So, cost of sweat and other litigations expenses, if may also require that a violator to submit a program of rehabilitation or restoration of the environment, that cost of which shall be borne so by the violator or to contributor to a special trust fund for that purpose or subject that the control of the court.